Hi, everybody. Welcome. We're glad you're here. I'm Alyssa DeFilippo, Program Manager at Parents Helping Parents for Connections California, our online statewide resource and information hub for transition to adulthood and adulthood services. So this evening, you are at How to Involve Siblings in Financial Planning for Your Adult with a Disability. And we welcome Ellen Cookman back to the Connections California screen. Ellen is gracious enough to return after a fabulously successful series of 4 events in the fall about public benefits and special needs planning. And this evening, she's going to focus on financial planning with sibling involvement, which I think it's something that's near and dear to my heart right now, and probably to a lot of you out there. And for those of you who don't know Ellen, she started Cookman Law in 2015 to help families of all shapes and sizes plan for the future and utilize available resources. And Ellen is a certified specialist in estate planning, trust and probate law from the California State Bar Board of Legal Specialization. It's a mouthful. And as we all know, many families need parenting when you're gone. And Cookman Law helps families put together a team of professionals and family members to provide additional financial and care management and support. They also offer trust administration services when needed. So we thank you, Ellen, for being here tonight. Moira Alberton, who is actually from a sister agency down in San Diego, might be popping on to help with Q&A a little later. So we'll see her, or we may not, it depends. But I am going to turn it over to Ellen now. And again, we thank you for any donation. No donation is too big or small. We're grateful for them all. Okay. Thank you so much, Ellen, for being here, and everyone, and Beatrice. And here we go.
All right, let's see. I did not share the right screen, so give me just 1 second. There we go. This one should be working. Okay, terrific. Well, thank you so much. I'm so thrilled to have this invitation. And I know we spoke a lot about estate planning last year, and we wanted to continue the conversation with estate planning, but to look at it from a slightly different perspective of how do we involve siblings, right? A lot of you may have family members who, who have different abilities, right? In fact, my kids are the same way. So you'll see a few of my accolades and stuff. But you'll see the bottom one is that I'm a parent of a child with special needs. I have a 12-year-old named Caleb who has high functioning autism or level 1 autism. And then I have a neurotypical 11-year-old. So they're 19 months apart, and they're great friends when they're not fighting. But I think about these things like how might my younger son end up supporting my older son? What is that going to look like? And how do I set them up for success? So whenever we're looking at estate planning, well for today, we're going to look at a few different things. We're going to look at sibling involvement when it comes to special needs trusts and ABLE accounts. But first, I want to give an overview about public benefits, because you kind of need to understand that to understand why we need special needs trusts and ABLE accounts in the first place. So today, right, we're looking at if you have 2 children or maybe more, maybe you have multiple children and they have different needs. One child might need more care during their lifetime. They might need more financial support. And then the other child might be off living their best life. I know Isaac, he really enjoys theater, and he may end up somewhere else, right? And then Caleb, he for a long time he wanted to stay close by, and now he's looking at Chicago for college. And okay, it's cold there, right? But we don't know where they're going to end up, and we don't know, how it's going to work. And so there's a lot of things to consider. And 3 main categories of what we're going to really be thinking about is, how much should each of your children, or if you're a sibling, you and your other sibling, inherit from you? Should that be equal? Should it be unequal? A lot of times we want to treat our kids equally, but they have different needs. They have different abilities to earn their own money. And so maybe it's not the best idea to leave things equally. We also want to see, okay, how will they receive their inheritance? What type of trust is the best trust to receive that inheritance? And so, we'll talk about special needs trusts. We'll also touch on dynasty trusts. And we'll also look at, inheriting outright to see which one is appropriate when. And then also, who's going to be managing the disabled child's money? All right, that's a huge, huge issue that often, as we're going to talk about, it often defaults to the neurotypical sibling, but sometimes that shouldn't happen. So we have some overall goals when we're doing special needs planning. We really want to maximize everyone's quality of life, right? We want to maximize the neurotypical siblings' quality of life and the disabled child's quality of life. We want to protect, especially protect the disabled child from financial predators, sometimes protect them from themselves. And yet we want to maximize their independence. So you can see how those two things might be in conflict with each other. If the child is receiving public benefits, we want to maximize those public benefits because that can really help to support them throughout their lifetime. And and when we're doing special needs planning, we're really setting up surrogate financial parents. And should the sibling be that? That's one of the big questions. And of course, I may be an estate planning attorney, but I hate going to court. So we want to avoid the court system whenever we can. All right, so let's look at public benefits. I have one slide on this, but I include all the information. So I'm going to kind of walk you through this. And really what happens is when your child turns 18, all of a sudden they become poor and they if they don't already have their own money, right? Because your money is not attributable to them when they turn 18. So they can qualify for certain public benefits because they have low income or low resources. All right. I think of this as if somebody were neurotypical and they were able to work and support themselves, they'd get an income stream, a salary, and they'd get health insurance. And so we need to find a way to provide those things to someone who is not able to work and support themselves due to their disability. And so that's what this chart is all about. So on the upper left, we have an income stream that we call needs-based. That means you need it because you're poor. All right, you see that line, resource limit of $2,000. What that means is you must have under $2,000 of countable assets in order to qualify for SSI. It's really restrictive, right? And you can get about $1,207 a month. That's the maximum amount. Now, SSI is meant to supplement any other income sources that you might be receiving. So the disabled child might be working part-time, they might be getting some SSDI, some other forms of income, and then SSI kind of supplements what they're already getting. But you only qualify if in the bank you have $2,000. Then if you receive even $1 of SSI, you automatically qualify for Medi-Cal, which is California's version of the federal Medicaid system. Now, the good news about Medi-Cal is that last year, California eliminated the resource limit. So in every other state and in California before, well, it was actually 2022, there's a resource limit of $2,000, just like SSI. But that doesn't exist in California anymore. Now there's no resource limit for Medi-Cal. However, there is an income limit and it's about $1,800 a month. So if you have a regular trust that's generating income, that will count against your Medi-Cal benefits. And also under the Medi-Cal umbrella is IHSS, in-home supportive services. So some people are not as concerned about the health insurance, but they really need to protect the in-home support services, which can pay for a caregiver to take care of a child at home and take care of their activities of daily living and anything that they might need. So now on the bottom, you see entitlement-based public benefits. So at the bottom left is Social Security disability insurance. So that's if somebody's paid into the system. That's why they're entitled, right? They've paid in for a while. And then, now they get an income stream. Another form of that is if somebody's paid in for a while and then they retire And then their child who became disabled before age 22 can get benefits based on the parent's retirement income. So let's say a parent is receiving $3,000 a month. The child can get half of what the parent's receiving, or $1,500 a month. So that's a really nice benefit. And when the parent passes away, the child gets 3/4 of what the parent was receiving. So both of those are entitlement-based benefits. There's no resource limit, and there's only an income limit if the child is working. There's no passive income limit. Then after 2 years, one really nice thing is if you're getting SSDI or child disability benefits, you qualify for Medicare, right? Which, most people, some people on this call might be receiving it if you're age 65 or older. Well, you can get Medicare younger than age 65 if you're receiving one of these benefits, SSDI, CDB benefits, right? And Medicare has no resource limit or income limit. So here's the issue. If a child receives an inheritance outright or an inheritance into the wrong trust, that can count as a resource and that can bump them off their SSI. And if they receive that inheritance into the wrong trust and it's the money is invested in generating income, that income can bump them off of Medi-Cal and IHSS. So we need to set up what's called a special needs trust for the child, right? So a special needs trust it's a trust that becomes, well, what is a trust? A trust is I always want to think back to when I first heard of a trust, because there was a time that I didn't know what a trust was, right? So a trust is an agreement that you set up between the person setting it up and funding it and the person managing it for the benefit of the beneficiary. Now, most of you on this call, you likely have a revocable living trust where you are the one setting it up and you are the one managing it for the benefit of you. You wear all the hats. And that is mostly to avoid probate, and it's also good for management purposes. A special needs trust is also a trust, but it's a different type of trust than a revocable trust. The special needs trust needs to become irrevocable. You can't change it once the money goes in. And it holds assets for a disabled person. So the disabled person is the beneficiary, and it doesn't interfere with public benefits. And the reason why it doesn't interfere is because you have somebody else acting as trustee. Somebody else is the gatekeeper for the money. The child cannot reach in and grab money out of the special needs trust. The child can't revoke the trust or change the trust, all right? Because the child doesn't have any control over the money in the special needs trust, it doesn't count as their money for SSI purposes, for Medi-Cal and IHSS purposes. So it's really nice. It's like a safety net of money for anything that public benefits doesn't pay for. And it's very broad, as this court case says, all right? This is a court case from 2023 that says special needs encompasses the broad range of everything a human being needs in order to live, thrive, and realize his or her potential in life. I mean, isn't that beautiful, right? No, it's anything that can improve your quality of life. So my favorite example is a trip to Disneyland. I have one team member who's at Disneyland right now as we speak, and I'm sure she's having a great time with her $2. That could be covered. A trip to Disneyland could be covered by a special needs trust. All right, so there's this fallacy out there that special needs trusts are restrictive or you can only pay for a few things. That's really not true. As long as the special needs trust is drafted properly, it can pay for just about anything. Now, there's actually two types of special needs trusts. Well, two main types. There's the type that the parents or somebody else will set up for the disabled child. That's called a third-party special needs trust. And then there's the type of trust that a disabled child sets up for themselves or puts money in, their own money in. And that's called a first-party special needs trust. The distinction is the source of the funds. All right. If somebody else's money is going into the special needs trust, that's a third party special needs trust because that somebody else is a third party in relation to the child. But if the child has their own money, let's say there's a litigation settlement or they received an inheritance outright and now they need to turn around and put it into a first party special needs trust, that's the type of trust that they'd use because they are the first party. Now, first-party special needs trusts are not as beneficial as third-party ones because first-party special needs trusts, they have to have a Medi-Cal reimbursement claim embedded within. So what that means is on the child's death, everything going to wherever the trust says first is subject to Medi-Cal payback claim. So anything that Medi-Cal has paid for the child during their lifetime, Medi-Cal gets to take that money out before any remaining money goes where the trust says. A third-party special needs trust doesn't have that provision built in. Okay, and there's a few other differences between special needs trusts, but I'm not going to really dive into those. But I do want to let you know I have a YouTube channel and I have videos on just about every topic that we're talking about here. So if you want to look into first-party special needs trusts or third-party special needs trusts, you're totally welcome to. But I really want to focus more on the things that really affect siblings. So one of the big ones is the choice of trustee. All right, so now we're looking at somebody has a third party or first party special needs trust, and we're saying who's going to manage it? Well, initially the parents can manage it, right? They can be trustee if they're able to, but usually the trust is funded when the parents are gone, when they die. Their revocable trust will say, upon our death, we want this money going to Joey to instead go to his special needs trust, and then the money goes there when the parents die. So the parents aren't alive when the trust is up and running and it needs to be administered. So you need to choose a successor trustee for that. Now, what most families do when they come in, if they haven't watched my videos, if they've watched my videos, they've thought about this a little bit more. But if they haven't watched my videos, they come in and they go, well, I don't really know of anybody. I mean, I guess I'll ask Janie, Joey's sister, to act as trustee because she really knows Joey. She really cares about him. I trust her. She's the neurotypical sibling. I don't think that's a great idea, and I'm going to talk about why on the next slide. But let me also kind of bring up some other choices that people might think about. They might choose a family friend. I just want to say a lot of times that's not a good idea because that friend might have other things going on in their lives. I've actually had to go to court before when a family named a neighbor, a close neighbor, as successor trustee, and that close neighbor had her own life and her own things going on, and she couldn't act as trustee. But the trust that I didn't draft, but the trust didn't provide a way for her to name a successor trustee. So we had to go into court to name a private professional fiduciary as successor trustee of that trust. Okay, so a private professional fiduciary is a person who acts as trustee of trusts. That's what they do. This is their job. Sometimes they'll act as conservator or guardian. Sometimes they'll act as bookkeeper, but typically one of their main roles is acting as trustee of a trust. Now, not all professional fiduciaries act as trustee of special needs trusts, but some do. And so, one big job is to look around and, try to find one that you really get along with if you're thinking about that. Another option is to name a bank or a trust company. So there are some banks, not a lot of banks, but there are some banks that act as trustee of special needs trusts. Now, I think banks can be a really good choice because they offer the longevity that you might need. If your child is age 20 and, let's say you die 5 years later, they're 25, they could live another 65 years, right? Another long time. And a private professional fiduciary, the drawback of that is they're human and humans die, humans retire, humans, they have health scares. So a bank has that continuity. Even if they give up their trust department, somebody else is going to take it over. Then there's also something called a trust company. So that's really, it's kind of like a bank, but they don't usually manage the underlying assets. You'd kind of bifurcate the roles where the manager of the underlying assets would be a financial advisor. And then the trust company would deal with making distributions and filing all the tax returns, doing all the trustee work. Okay. There's also some nonprofits that act as trustee. And then there's something called a pooled trust. So basically that's a nonprofit that pools together a lot of smaller special needs trusts. And then sometimes you can combine them. You can name, for example, you can name a family member as co-trustee with a bank or a trust company. So why did I mention that I think it's usually a bad practice to name a neurotypical sibling as trustee of a neurodivergent sibling's special needs trust? Why would that be? Well, managing a special needs trust is a lot of work. All right. You may have managed your parents' trust. Maybe your parents passed away and you did the trust administration process, or maybe you've never managed a trust before at all. Um, but that type of trust administration, that type of management of a trust usually lasts, I don't know, 4 to 6 months, unless there's something weird that comes up. Managing a special needs trust, that lasts for years and years and years, okay? You also have to understand all the public benefits rules to make sure that your child doesn't get bumped off of their public benefits. And you have to understand the legal requirements and financial regulations. It's a lot of work. Did I mention that? And it's a big time commitment, right? You need to prepare well, you'd work with an accountant who would prepare accountings and do the tax filings. So you always kind of need to be involved. And then the sibling, this can cause a lot of conflict because the neurotypical sibling is basically the gatekeeper, as I mentioned, of the disabled sibling's money. And that can really affect family dynamics and cause a lot of stress. I think about, like, if I were to name Isaac, my younger child, as trustee of Caleb's Special Needs Trust, oh, there would be explosions all over the place. It wouldn't be great. And then the other thing is we want your child, well, we want both children, but especially your neurotypical child to be able to travel, live their life, have their kids. They're very busy. If you know any 30, 35-year-olds right now, they're incredibly busy, trying to juggle jobs and kids' responsibility and maybe managing a business. They do a lot of things nowadays. So that's a lot to put on a sibling. So what role might be better for the sibling? A trust protector. All right. So a trust protector is basically the overseer of a trustee. All right. So they get to see how's the trustee doing, and if they feel like they're not doing a good job, then they can remove and replace the trustee with somebody else. Okay, so they get to stay involved. They get, yearly accountings. They have access to the books, but they're not responsible for the child continually. They don't have to check in with their disabled sibling every day and take multiple calls, especially, I want to point this out, especially if you have a disabled child with mental health challenges. In those situations, I say, never, ever, ever name the neurotypical sibling, because, well, you probably know why, but that causes an incredible amount of stress, or it can, for the neurotypical sibling, getting multiple calls if the child's in a manic state, like it crashes and burns. Um, and I found that siblings really like this role because they want to be involved. They want to, have some role and make sure over time that their disabled sibling is being taken care of. But they don't want to have the primary responsibility the way that they've seen their parents do this. Their parents step up. I mean, it's been estimated that parents put in like $150,000 a year worth of work. Oh, hello, it's my dog. Um, and and that's free, like parents are volunteering that, but the neurotypical sibling usually can't do that. All right. So having the sibling be the trust protector tends to work out very nicely. Now, one thing I like recommending and I think is very important is to write something called a memo of intent. So this is basically, dear successor trustee, here's everything I want you to know about my disabled child. All right. What makes them happy, sad, what allergies do they have, which family members should they be interacting with, how should the sibling be involved? So if you want, if you're a parent and you want the sibling to have more responsibility, you can put that into the memo of intent. So it's not binding, it's not signed into law with the trust, but at least, the sibling has that opportunity to be more involved in certain ways. Maybe sibling takes their brother or sister out to lunch once a week, and you can encourage that to continue to happen. Also, if you have some ideas about housing, that can be really good to put in a memo of intent, especially in California, in the Bay Area, where it's so expensive. If you've figured out housing for your child, please spell it out, because that's a big issue. I've interviewed several women who have set up some very creative, and men as well, very creative housing opportunities for the disabled in the Bay Area. So those are on my YouTube channel. Okay, so sometimes families come in and they bring their big, long, revocable trust, and they say, okay, see Article 6, that's where the special needs trust is. In fact, I had a conversation with a client today where that happened. Okay, the parents had already died, and the special needs trust was embedded within the revocable trust, but it was really hard to find. And they wanted to set up a bank account for the special needs trust, but the bank was like, I can't read this 20-page paper. What is this thing, right? So I usually recommend doing what we call a standalone special needs trust. So this is a special needs trust that can become effective immediately. You don't have to wait for the parent to die, all right? With a revocable trust, the parents have to be gone in order for the special needs trust to spring into being. That's why we call it testamentary, because it only exists when the person dies. That's the word testament, right? Like last will and testament. Somebody dies, and then the special needs trust exists. With a standalone special needs trust, it's available. It's available even during the parent's lifetime. So if the parent wants to put some money into the special needs trust, if a sibling, if an auntie or a grandpa want to put money into the special needs trust, they can do it at any time. The other thing that's really important is when you die and special needs trust is funded, the Department of Healthcare Services is going to want to see a copy, or Social Security Administration, they'll want to see a copy of the special needs trust. And if you send them the full-on long revocable trust, they'll get super confused and they won't know, which part is this, which part is that. And they just, I've heard of situations where they've had to cut and paste. The attorney had to cut and paste the sections relating to the special needs trust because otherwise, the Social Security Administration wouldn't accept it. All right, so how should we fund the special needs trust? Well, you can put a lot of different things in it, right? Of course, cash is the most convenient type. We also have investment accounts. Okay, so it can hold um, securities and stock options or stocks. It can also hold houses. All right, so you can leave a house or a condo in a special needs trust. Of course, the special needs trust is intended to receive an inheritance and gifts. As I mentioned, with a first party special needs trust, usually those are set up to receive a settlement. Also, you could name a special needs trust as the beneficiary of a retirement account, right? So that can be a really good option, especially from an income tax perspective, and also the beneficiary of a life insurance policy. Some families are worried that they don't have enough to leave to their kids. Life insurance can be a good way to add to what your child might be inheriting because it's a less expensive way to fund it when it's needed, which is usually when the parents are gone. So now one big question that comes up, okay, I'd say there's two major questions when I'm working with families that have kids of different abilities. All right. One of them is who's going to be successor trustee. And the other one is how much should we put in the special needs trust? All right. Should you leave money equally to all the kids? Well, I'm not a financial advisor, so I don't do financial projections. But I usually recommend to my clients that they go to a financial advisor to project out how much does that child need to live on for the rest of their lifetime. And this is a complicated calculation because it's not just like if you're going to retire, how much do you need over the next 30 years? This is, your child might have some very challenging needs. We may not know the progression of their illness. So, there might need to be a lot of flexibility in there. And not all financial advisors will do or should do financial projections for kids with special needs. In fact, I'd say most of them don't know how to. There is a certification called a Chartered Special Needs Consultant, and those folks learn how to in their certification process. So I usually recommend looking for one of them, or at least a financial advisor who regularly works with the special needs community. So once you decide the amount, you can actually leave that amount, sometimes indexed for inflation, to the child with special needs. So you say, off the top, when we die, this amount, $3 million, $1 million, $500,000 is going to the special needs trust for Johnny. Everything else gets divided among my other children. So you know that, whether you have a lot or whether you have a little, the amount that needs to go to that child will go there. The challenge with naming, percentages to each kid is you don't know how much you'll have when you're gone. And so will that percentage be enough for the child? We don't know. Now, I do get some pushback from clients and others, saying, well, I'm worried that my neurotypical child will be resentful that their, special needs sibling is getting more money. They're not getting enough. But then oftentimes when you circle back to the neurotypical sibling, they're really happy that their disabled sibling is being taken care of and it's not falling on them. Okay. Very frequently when clients first come in, if they bring, and for our meetings, you're welcome to bring anybody along, any family members or professionals, but when they bring their, the neurotypical sibling along, their child who's, doing very well in life, and I mentioned to them, okay, you don't actually have to manage the special needs trust or take care of that. A look of relief comes over their face. They are so, so glad. So, and a lot of times they recognize that their disabled sibling needs all the money that they can get because that's it. If they run out of money, game over. Or even worse, if they run out of money, that disabled sibling is going to be on the neurotypical sibling's doorstep asking for money. And that neurotypical sibling does not want to deal with that, especially with mental health challenges, right? So, so I often recommend the cash amount off the top, or if you're pretty certain that the percentage that you leave to the special needs trust for your disabled child, it will be sufficient, then go ahead. You can leave percentages. All right, so I don't want to leave out the neurotypical child from planning options. All right, a dynasty trust can be a great vehicle to inherit your money in, and it's very protective. All right, the three main big protections are if the neurotypical child ever endures a divorce. Okay, all of the money is segregated and it's separated. So let's say the dynasty trust, they're married and the dynasty trust buys a house. Well, everybody enjoys the house, but the child still owns the house in the dynasty trust. And then if the child and their spouse ever split and get divorced, the entire property remains in the dynasty trust and stays with your child. Okay. Also, there's a very high level of creditor protection. So if the child ever gets sued, basically they need to step aside from acting as trustee, and then there's a very high level of creditor protection. And then the third benefit is if your child is doing really well financially and you don't want to add to their taxable estate, leaving money into a dynasty trust actually skips the generation from the child to the grandchild. So say you leave, I don't know, $1 million to a dynasty trust for your child, and then that money grows and grows and grows. It becomes 5 million, $10 million. When the child dies, all of that money goes to the child's children free of estate taxes. So that's actually why the dynasty trust was created in the first place. It was created for estate tax avoidance, but I really like it for the other protections. So I have two videos online about dynasty trusts. So, I encourage you to go watch them. And you can talk to your parents about, hey, mom or dad, can you set up a dynasty trust for me? Or maybe you decide, I don't like this thing. And you talk to your parents about, I'd rather not receive my inheritance in that. Okay. So I'm going to pause for a minute, if that's okay, Alyssa, because I want to see, because we're going to move into able accounts, but I do want to see if there are some questions out there. So is now a good time to pause, Alyssa? I don't know if you're,
I am here.
yeah, okay, great.
And we do have a couple of questions
Mhm.
that you could address right now if you would like.
Yep.
And that is, do we need to name the trust protector in our living trust and our special needs trust?
Ah, for a revocable living trust, a lot of times you don't need a trust protector because it's a compact period of time, right? To administer the trust. Usually there aren't a lot of things that come up. Typically it's when the money gets into the special needs trust, that's when a trust protector can be so powerful. But you can name a trust protector in a revocable living trust. I've done that before, but it's just not that typical.
And not necessary potentially.
Usually it's not necessary.
Yeah,
That's right.
because it's a limited time period. Okay.
Exactly.
And can you set up a standalone special needs trust after both parents are gone?
Well, okay, if the revocable trust says that the money goes outright to the kids and the parents die before changing the revocable trust, then you need to take some additional steps to get that money into a special needs trust. You might have to go to court and petition the court to modify the parents' revocable trust to build in a special needs trust, or the money might go outright to the child and then you turn around and set up a first party special needs trust. So there's certain ways that you can do it. But once the parents are gone, it's kind of too late to set up a special needs trust for their benefit.
Okay, thank you. And then what happens if you want to leave the house in the trust, but you still owe a mortgage?
Mm. Well, houses can be tricky to leave to kids because you also need to leave cash. And
Mhm.
you not just any amount of cash, like a lot of cash, because if you own a house, you know how expensive they are to maintain and all the different things that go into it. And if you have a child who's going to be living in that house alone, then you also usually you need a caregiver to come in. You need a property manager. So it gets incredibly expensive. So usually I recommend not trying to keep the child in the house, if at all possible, just because you'll need another $1 million, $2 million of cash to support it. So if you have a mortgage, then most likely that mortgage will need to be paid off um, before the house goes into the special needs trust. Just because if you're trying, it's let me just put it this way: it's difficult to once. I'll back up. Once the parents die and the house is going to be distributed out from the revocable trust to the special needs trust, usually the mortgage becomes due in full because the original owners are gone, right? So that's over. So then the special needs trust would need to obtain a new mortgage on the house. But most banks don't lend to irrevocable trusts because they just don't have an income stream there. Okay. There was one bank that I loved who sometimes would lend to irrevocable trust, and that was First Republic Bank. And they're gone. So, that might give you a few reasons why. But they were awesome and I loved their chocolate chip cookies. Anyways, I digress. So usually the mortgage will need to be paid off.
Okay. Um, where was the one question I wanted to ask you? So, some confusion about if someone leaves an inheritance, how it affects the benefits, what happens if one parent passes away, how is the trust funded, just kind of around how funding the trust could impact SSI or SSDI, just a lot of confusion around the funding and the public benefits.
Okay. So the special needs trust is drafted in such a way that when money goes into the special needs trust, it does not affect public benefits. That's why we do it in the first place. All right. So a properly drafted special needs trust, when the parents die and money goes into the special needs trust, the child should continue to receive their public benefits. Now, with that said, Social Security Administration wants to look over the trust to make sure that it's a properly drafted special needs trust. So you have to feel very confident in the person who drafted your trust, your special needs, your child's special needs trust, to know that for sure it'll work. And I want to tell you a dirty little secret, right? There's a lot of estate planning attorneys out there who don't understand about special needs planning at all. And they don't know what a special needs trust should say, but they have a drafting program where they can press a button and it populates a special needs trust within the revocable trust. And they figure, well, I won't be around practicing any longer when the parents die, so it doesn't really affect me. And yeah, it's good enough. Is that good enough? No, no, these are your kids that we're talking about, and you won't be around to make sure that it works. So make sure that you go to a special needs planner who really understands their stuff to make sure that your special needs trust is properly drafted. Sorry, went on a little rant there.
Sorry, that's okay. I was having a coughing fit, so it was good timing. Um, if a parent passes away and the trust is funded, what happens if the client passes away and there's money still in there?
Um, okay, so if the parent passes away, and maybe they meant, and then the child passes away, the disabled child dies.
I think so.
Okay, so if there's money remaining in the special needs trust, it goes wherever the special needs trust says. So when we originally draft the special needs trust, we have to describe what happens to the money remaining when the disabled person dies. Does it go to their sibling? Does it go to charities? Does it go some here, some there? And that's where it will go.
Okay. And uh, just sort of you mentioned the house and you
Mhm.
mentioned being able to leave money for the maintenance of that house. So
Yeah.
someone is saying, would you recommend leaving the house to the adult with special needs if the mortgage is paid in full?
Well, again, you still need a lot of cash to support the house. So I would recommend doing financial projections. How much will it take, will it cost to pay all the California property taxes? What if the roof needs to be replaced? Who needs to be in the house with the child? Does the child need additional transportation because the house is way far out in the country or up in Los Altos Hills and they can't get to public transportation? What does that all look like? Okay. Um, a lot of times it's more beneficial, even though it can be a transition for the child, to sell the house and then put the child up in a one-bedroom apartment or in a condo that's really close to all of the services that they might need and closer to their friends. It can be very isolating to live in a big house. So there's a lot of reasons why I usually recommend not trying to leave the house to the disabled child. But some families really want to, and I respect your decision.
Mhm. Okay. And I think maybe we'll just have this is the last one, and it's the do you set up a dynasty trust after both parents die and split the assets among the children the same way you do for a special needs trust? And I think I know the answer to this.
Oh, do you want to tell us the answer?
Well, I think the answer is yes. That is when the dynasty trust is funded, but it needs to be written into the trust, so it's a mechanism that kind of kicks in when the
Exactly.
second parent dies or if both parents die together in the plane crash while they were coming back from Hawaii. You know,
You
that kind
got
of thing.
it. You got it. Yeah.
Yay!
So yes, so the dynasty trust needs to be created during the parent's lifetime, but it could be not funded until the parents are gone. Um, you can't, in California, you can't create a dynasty trust for yourself and fund it yourself. We have rules where creditors, that's basically like leaving creditors out in the cold. And so you can do that in another state. So if you're like, and there are some like maybe some people who are like OBGYNs, or they're in a profession where they get sued a lot. They may choose to set up a trust in Nevada and have a Nevada bank or trust company act as trustee. Then they can put their own money into that trust in Nevada, that dynasty trust, and it's protected. But you can't do that in California. You can only set up and fund a dynasty trust for other people rather than uh, yourself, and you can't do it for your spouse either. Okay. Okay, so let's
Okay,
keep
yeah, let's
diving
go
on.
on. Yeah, I think we
Okay,
should
let's
go
go
on
on,
because
and then we'll have
this group, well,
yes, we'll
let's
have
speak
more
all
time for
night.
questions.
Yes.
Okay, so I do want to go over ABLE accounts because those are an important part of the special needs plan. So what is an ABLE account? An ABLE account is basically a savings account for a disabled person that's modeled after a 529 plan. If you're familiar with an education savings plan, 529, this is a 529A plan, okay? And so basically post-tax money goes into the ABLE account, and then it can grow and grow and grow. And as long as you use the money for qualified disability expenses, there's no capital, you don't have to pay money on the capital gains tax. So that's really nice, okay? The main restriction with an ABLE account is that you can only put in $19,000 each year. And that is the annual exclusion amount for gift taxes. So that goes up a little bit each year. So it's not intended to receive a big inheritance. You only can put in 19,000 each year. And that's not mom puts in 19,000 and dad puts in 19,000 and grandma. Nope, it's just 19,000 and it's capped off. Now, this is a really powerful tool because it doesn't interfere with public benefits. Just like a special needs trust, when you put money into an ABLE account for a disabled person, it doesn't count towards that $2,000 limit for SSI purposes. This is a really great savings tool. So here are some rules, right? So you need to use them for qualified disability expenses. I have a slide on that, and it's very broad, by the way. Now, another big restriction is that the child needs to have become disabled before age 26 in order to set up an ABLE account. But happily, that age next year is going up to age 46. All right, so that's really good, especially for the mental health community and for people maybe who got into car accidents later in life. So that is one requirement of when the onset of the disability occurred. You can set up, if you're disabled, you can set up an ABLE account for yourself and you can manage it yourself. Or somebody else can set it up for you and somebody else can manage it. They're called the authorized legal representative. It's similar if you have a child who's receiving SSI or SSDI benefits, and you are the representative payee, which is like the manager of that money. The manager of an ABLE account is called the authorized legal representative. So that you can set that up too. And that could be the spouse of the disabled person, a parent, it can be a sibling. So you can have a sibling acting as the manager for a disabled sibling's ABLE account. Anyone can make contributions to an ABLE account. So this is different than a special needs trust, where if you have somebody else putting in money, then that has to be a third-party special needs trust. And if you have the beneficiary putting in their money, that has to be a first-party special needs trust. With this, we only have one ABLE account. And the disabled person can put in their own money, the parent, the other person, the sibling, they can all put in money. But of course, up to 19,000 each year. And you only get one ABLE account. So you can't set one up in California and then set one up in Ohio and set one up in Tennessee. You just get one. So here are some examples of qualified disability expenses. Okay, so it's again, it's anything to improve quality of life, just like a special needs trust, very, very, very broad. What doesn't it include? Well, gambling, cigarettes, illegal activity, but it is that, the trip to Disneyland, like my team member is doing right now, that could be a qualified disability expense. Okay, so a few other details. So you may have set up a 529 plan for if you're a parent for, your disabled child and you didn't know that they had disabilities when you set it up. And then you go, oh, wow, my child is not going to go to college and they don't need that money in a 529 plan, you can roll it over $19,000 a year into an ABLE account. Now that's set to expire in 2026, but I'm hoping that they'll extend it. You can also roll over money from a neurotypical siblings 529 plan to the disabled siblings ABLE account, or vice versa, okay, from a disabled siblings ABLE account to a 529 plan. But if it's going into the ABLE account, we're capped off at $19,000 again. Now, one really nice thing is if you have a disabled child who's working and receiving income, they can put their own income into an ABLE account in addition to the $19,000 that you typically can fund. So they can put in another about $15,000 of their own income as long as they're not participating in their employer's retirement plan, right? So in that case, what do we have? $34,000 going in just in 1 year. That's pretty cool. Now we're in California, and California loves to make its own rules. All right, so there's two things that California's done that's interesting. The first thing is they've set up these ABLE accounts to require Medi-Cal reimbursement claims, just like a first-party special needs trust. But the law allows states to opt out of the Medi-Cal reimbursement claim, and California has opted out. So yay. But then what California did, I think California realized, hey, there's people, there's California residents setting up ABLE accounts in other states. Why are they doing this? We want to discourage them from doing this. So they passed a new law starting January 2023 that if you're a California resident and you set up an ABLE account in another state, Medi-Cal can go after the money in that ABLE account in the other state. But they can't go after the ABLE account in California, which we call the Cal-ABLE account, because we always like cutesy names, right? So the moral of the story is, if you're a California resident, you need a Cal-ABLE account, period. I want to mention that there are some companies like Fidelity, I believe, that says, oh, you can set up an ABLE account with us. No, don't do it. That's a Massachusetts ABLE account. You want to set up a California ABLE account, and there's only one place to do it, and I think I even have the location, so we'll get there. So I mentioned contribution limits, so $19,000 a year. Another limitation is that the ABLE account, over time, it can grow to up to $100,000. If it goes over 100,000, SSI for the disabled person is suspended. So you want to keep it under 100,000 if that person's receiving SSI. But if they're not getting SSI, you can keep putting money in, and it can go up to the 529 limit, which in California is $529,000. Easy to remember, right? Yeah. All right, so when you sign up for the ABLE account, I think there's 8 different tiers of different types of investments. ABLE accounts only hold cash. They don't hold securities, they don't hold bonds, they don't hold houses, they only hold cash. And then they, run by Vestwell, they provide the investment opportunities. So it's really not intended to like supercharge your investments, okay? But there are some investment choices. And here's where you go to set up a Cal-ABLE account. You go to calable.ca.gov. That is the one place you go to. But before you go there to set one up, you have to set up a checking account or a savings account at your favorite bank. And then you provide that bank account information when you're setting up the Cal-ABLE account, because at that bank, that's where the money is going to be housed. Cal-ABLE does not offer their own checking accounts. You have to use a bank or a credit union's checking account. And then Cal-ABLE, which is run by Vestwell, will communicate with the account, the routing and checking account information, and they connect that way. Okay. You can get a reloadable prepaid Visa debit card. That's usually how you pull money out of the ABLE account. So here I have actually a couple of slides with nifty comparison slides. Okay, so So you can compare when would you want to use an ABLE account versus a third-party special needs trust versus a first-party special needs trust. And we'll make sure that these slides are available. So I'm not going to go into all of them, but you can always go back and look at these slides. All right, so that's really everything that I have to share. I will take more questions. Just to let you know, this is our firm, a sketch of our firm. We're in Palo Alto, but we serve all over California. We're completely virtual. And we have, although we do have an office in Palo Alto. So there's 3 attorneys, 3 paralegals, and the rest are support staff. And we do estate planning, special needs planning, and trust administration. We don't do conservatorships or counseling for public benefits or public benefits applications, just to let you know. And we're about to launch our trust maintenance program. So once you sign your documents, we can take care of you for the rest of your life. We're very excited about that. So last slide, we do have a newsletter that we send out once a month. And if you want to sign up for that, go ahead and, click on the QR code with your phone. And it'll populate an email to send to our team, and we can add you to the newsletter. And if you do decide to move forward with us in planning, we will make a $300 donation to Parents Helping Parents, because we want to support you guys. Parents Helping Parents, as you guys already know, is awesome in every way. So we want to support them. And finally, social media, feel free to connect with us, Facebook and LinkedIn. And I mentioned I have the YouTube channel. So let's turn it over to a few more questions. What do you say, Alyssa?
Okay, that sounds good to me. But first, please direct your attention to the chat where I have dropped in the links to the Spanish evaluation and the English evaluation. Again, 4 very simple questions. Please answer them, and we can continue to bring you quality programming like this. So, returning to the questions for just a little bit. By the clock on the screen, it is 7:30. You want to go for another 5 minutes, Ellen? I never like to overstep. Okay, thank
Yeah.
you. How about in the case of divorcing parents? Do judges for the child or adult support purposes by always putting the money into a first party trust, or can it go into a third party trust?
Okay. So that's relating to child support payments. Okay. So what happens is when you have an adult with disabilities, they will be receiving child support, but because they're age 18 and up, they can't receive the child support directly. So it has to be irrevocably assigned to a first party special needs trust. Third party special needs trusts don't work. The case law says, and the statutes say, it must go to a first party special needs trust. And I have a video called Special Needs Planning During and After a Divorce, where I talk about this. So feel free to watch that as well.
I did drop the link to Ellen's YouTube channel into the chat, and all the links that I drop into the chat will be in the email that goes out to everybody who attended tomorrow or the next day, along with the slides. So you'll have all those links and you'll be able to click to your heart's desire. I'm trying to answer some of these and type the answers that I can. But still a little confusion about putting funds into the wrong kind of trust, and it could impact SSDI or SSI. What about unearned? How about income and passive income? How does that get impacted? Just a couple of things that I think people had in mind
Yeah,
when they were applying. And
there's a lot of things that we didn't cover today. I do have, I'm going to sound like, when Elizabeth Warren was running for president, and she's like, I've got a bill for that. I feel like that. I've got a video for that.
And she does. And really, they're really good, and they're not that long, and they're very, very informative. My son
Yeah.
loves them too. So that's it.
Well, thank you.
Watch
Yeah,
Ellen's
we
video.
try to make them accessible to everybody. So I do have videos on how income impacts public benefits. We didn't have enough time to dive into all of that, but this is like a new language. So it's really something that you keep watching, you keep investigating, you keep researching, and so I can't just stop and explain all of, here's how income works, but I have videos on it, so please go look for them.
And maybe we'll have Ellen come back and speak on just that one issue. We
There
never
we
know.
go.
All we can
Yeah.
do is ask her to keep coming back. Um, I'm not sure this is in your wheelhouse, but how do you ensure that the property tax doesn't get reassessed at the time of the transfer of the home to a special needs trust if you are going to leave it?
Good question. I like that question. Not like other questions are bad, but that's a very interesting question. Okay, so when property is left to a special needs trust, they look at who is the beneficial owner. They look at the disabled person themselves and they say, okay, is that disabled person related to the person who died? And if they're a child, and if that disabled person moves in to the house, then under Proposition 19, which was passed in 2021, a parent can leave a child their own residence of, and then the child moves in, or if the child already lives there, the child stays there, and the first $1 million of reassessment is forgiven. Okay. Now that only works for a residence, and it only works if both the parent and the child make that property their residence. It still works if money goes into a special needs trust for the child. Just because it's in a special needs trust doesn't mean they don't get the exclusion from reassessment, because again, the assessor's office looks through the special needs trust to say, okay, who is the beneficiary of the special needs trust? It's a child of the parent, then yes, they do get that exemption.
The exemption of up to the million, the first
Exactly.
million.
That's right.
Okay. All right, great. Thank you. Um, uh, oh dear, 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 dear. How do you set up a tax ID number for a standalone SNT?
Ooh, well, you go onto the IRS website and they ask you some questions. I'm pretty sure I have a video of that. It's yeah, but yeah, you do go onto the website. You have to figure out, which social security number should be used, kind of as for the responsible party. You enter in the trustees' information. Are there any employees under that? What type of trust is it? So there's certain things that you need to, certain information that you need to provide them.
Okay, and then also I'm typing an answer here to how do we find chartered special needs consultants? And I think they mean planners, financial planners.
Right.
I'm saying
Yeah.
THP's resource directory has some, but do you have anything?
So it's run by a certain organization that a certification, and they don't have, I was just looking for it. They don't have a search engine on on there. One thing you might want to do, yeah, go to Parents Helping Parents for sure. Also, Academy of Special Needs Planners has members who are attorneys and financial advisors, and some professional fiduciaries as well. And so, if you look for financial advisors and on their search, their professional search, you might find some, because even if they're not chartered special needs consultants, they're at least putting themselves out to the community as, hey, we work with the disabled community and we're willing to put our money where our mouth is.
And there's also that specialneedsanswers.com. I think that's
That
a
actually is
good
run
site,
by
right?
Academy of Special Needs Plans. And I hope that this helps create some great, wonderful family dynamics in the future.
All right, thank you. And I have to say that Ellen is helping our family, and my mind totally shifted after conversations with Ellen and then conversations with my son. So think about that. I just really want everybody to really think about it before we just think, oh yeah, the sibling can be the trustee, no problem.
Right.
Okay. All right.
Excellent.
Thanks everybody for coming. We'll see you next time. Take care.